Good afternoon, everyone. Glad to have you here. We are going to have a speaker you're going to hear about in a minute. Next time, we're going to have Lieutenant General retired McMaster on a video. McMaster on a video, who will give his take on what's happening. And if you have not signed up for the newsletter and would like to, this sheet is up there on the counter. And without further ado, I'm going to turn this over to Susan Platt, and she will introduce our speaker.
Thank you, Ann. Thank you. Well, I'm glad to have such a good audience for this important speaker. Ronald Slye. Oh, I was going to read the, if you don't mind, the acknowledgement of the native land. I'll begin with that. I would like to begin by acknowledging that we gather together on the ancestral homelands of the Coast Salish peoples who have lived in the Salish Sea Basin throughout the San Juan Islands and the North Cascades watershed from time immemorial. Please join me in expressing our deepest respect and gratitude for our indigenous neighbors, the Duwamish, Suquamish, Nisqually, Snoqualmie, and Muckleshoot tribes, for their enduring care and protection of our shared land and waterways. And it seems particularly appropriate to bring that in when we're going to be talking about international human rights and justice. So our speaker today, Ronald Slye, is a professor of law at Seattle University, which, as you know, is very close. But he spent a great deal of his career traveling the world and doing various very important commissions. I thought I would mention just a couple, because there's 14, how many pages? He was in the Law and Peace Practice Group in, are you still? Still is, Barcelona, Spain. And he was a founding member of a consulting group providing advice on the challenge of balancing legal security and justice in relation to negotiated transitions out of war or authoritarianism. I think we need you right here now. He provided assistance to individuals and organizations related to, for example, Colombia, the Gambia, Iraq, Nigeria, Somalia, Venezuela, and Zimbabwe. The second commission I'm going to mention is the Truth, Justice, and Reconciliation Commission based in Nairobi, Kenya. And he was chair of the Human Rights Violation Committee, one of 3 international commissioners appointed by the African Union to a 9-person commission. He was tasked with unearthing and analyzing, keep in mind this is South Africa, gross violations of human rights, including socioeconomic rights, economic crimes, corruption, and land distribution over a 45-year period. So that's just 2 of the commissions that he served on. He also went to Guantanamo in 1994, which at that time was holding Haitians and Cubans. That was before the war on terror in Iraq. But nowadays, we're hearing that they want to put some more Haitians back into Guantanamo. So that's a kind of eerie parallel. So without further ado, I give you Ronald Slye.
Thank you very much, Susan, for that very kind introduction, and thank you for inviting me here to talk to you. So I'm going to talk today about the International Criminal Court, which is sort of at a crossroads even before the Trump administration, which has now started to impose sanctions, pretty severe sanctions on the court. The International Criminal Court had been facing a number of challenges, even controversies. So what I'm going to do is first, this is just sort of a roadmap. of what I'm going to talk about. I want to give a brief history of international criminal law, how we got to the creation of the International Criminal Court. I want to talk a little bit about the structure of the International Criminal Court, what its jurisdiction is, what sort of crimes it covers, who it can who it has authority over. And then talk about some of the recent cases before the International Criminal Court, particularly Russia and Israel-Palestine, and also I'll make a reference to Afghanistan, which has become more relevant again recently. And then conclude by talking about some of the challenges facing the court, some of them sort of long-standing critiques of the court, and then obviously more recent events. So the major precursor of the International Criminal Court were the international tribunals set up in Nuremberg and Tokyo to prosecute, in the first case, Germans, and in the second, Japanese officials for crimes committed during World War II. This was a major development in terms of international law. It was the first time that after a war, after a conflict, responsibility was shifted from state responsibility. So normally you would say, you know, we hold Germany or Japan or whatever the country is responsible for, whatever the crime is, and then sometimes ask for reparations from one country to another. But really piercing the veil of sovereignty and looking at individuals and holding individuals criminally responsible for the acts that they committed on behalf of the state. So it's applying some notion of universal law to individual government officials. The crimes, there were 3 crimes that were prosecuted at Nuremberg and Tokyo. One that was considered the most important at the time was called crimes against the peace, which today we would call aggression. That's sort of the decision to go to war. So Germany invading Poland originally, and then other countries. Japan attacking the United States, Korea, China, etc. The second was crimes against humanity. Now, what we call the Nazi genocide, the Nazi Holocaust, was prosecuted under this title of crimes against humanity. So crimes against humanity is defined as a widespread or systematic attack against a civilian population. The term genocide had been coined by Raphael Lemkin before the creation of the Nuremberg Tribunal, but it was not put into the statute. There was, I think somebody went through and looked at all the transcripts. I think there's 1 or 2 references to the term genocide, but it was not a legal term of art, so people were not prosecuted for the crime of genocide at Nuremberg. And then the last, which was actually the least controversial, was war crimes. These were crimes committed in the context of an armed conflict. They're the most developed body of law then and still today is the law of armed conflict, or what some also call international humanitarian law. And that's law that regulates what one can do in the context of an armed conflict. So not deliberately targeting civilians, not attacking medical facilities, that sort of thing. So Nuremberg was created by a treaty by the 4 Allied powers, the United States, Soviet Union, France, and the United Kingdom. And there were a number of other allies that sort of signed on as well, but it was really formally a treaty between those 4 states. Tokyo, interestingly, was not created that way. It was actually created by a military order by Marshall that mirrored the Nuremberg Tribunal, but it wasn't created through that sort of more international treaty-based system. And one of the criticisms of Nuremberg and Tokyo was that it only applied to the individuals of the defeated parties, so there was no attempt to look at what the Allies had done that might also constitute, for example, a war crime, whether it's the firebombing of Dresden or Tokyo or the atomic bombings of Hiroshima or Nagasaki. So one of the critiques of Nuremberg and Tokyo is that it was one-sided in terms of who was held to account. So now fast forward to the early 1990s. Not between those two periods, that is the end of World War II, the late 1940s, until the 1990s, not really much happened in terms of international criminal accountability. The Cold War started the late 40s, so international cooperation in terms of creating institutions was stymied by the Cold War and the Western Europe, US, and Eastern Europe and the Soviet Union. Soviet Union collapses, former Yugoslavia, well then Yugoslavia, falls apart and devolves into a variety of different individual states, and a armed conflict then begins, which has very strong ethnic component to it, with a lot of civilians that are tortured, killed, rape centers set up, etc. So in 1993, the United Nations Security Council passed a resolution creating something called the International Criminal Tribunal for the former Yugoslavia. So this was the first international tribunal set up since Nuremberg in Tokyo, not set up through a treaty, sort of imposed, if you will, by the UN Security Council. And it gets up and running in The Hague and prosecutes a number of people on all sides of the conflict in the former Yugoslavia. 1994, you have the genocide in Rwanda, and pretty immediately after the end of the genocide, the Security Council creates the International Criminal Tribunal for Rwanda. So you have these two tribunals, courts, that are set up that are limited to those particular states and particular crimes committed in those particular states. The crimes that are covered are crimes against humanity, which I had mentioned, genocide, and war crimes. So genocide is included here, and in fact, the Akiyesu case, which is one of the first, might even be the first case from the Rwanda Tribunal, was the first international prosecution and conviction of someone for the crime of genocide. Genocide, the definition of genocide is the intent to destroy, so it's to destroy, not kill, although kill obviously is part of that, to destroy in whole or in part a group based upon ethnicity, race, religion, or nationality. So there's this specific intent requirement, which is sort of difficult to prove. It's limited to those four categories, that is race, ethnicity, religion, and nationality. So it's somewhat limited in what it covers, and it's somewhat difficult to prove, although it has been proven in a number of cases. There was also a case arising out of the Yugoslav tribunal where they found a particular massacre was in fact also met the definition of genocide. And I'm happy to talk more about the definition of genocide. Whoops, why was this taking me? Oh, I see. Sorry, user error. Okay, so then 1998, end of the Cold War, there's a lot more sort of optimism and ability to sort of create things internationally. Coalition of states, non-governmental organizations who had been pushing for a while for this, but sort of gets a lot more traction, and creates this permanent international criminal court, which actually had been contemplated at the end of World War II. In fact, the Genocide Convention specifically refers to the creation of a permanent international criminal court, but that never comes into being. So the International Criminal Court, unlike those two ad hoc tribunals for Yugoslavia and Rwanda, are created by a treaty. So states either agree to it or they don't. Today, there are 125 states out of roughly about 198, I think, or 200, roughly 200 states in the world that have ratified, that has become members of the International Criminal Court. This map gives you a visual sense of where those states are. I've listed the regions and regional representation. So you have 33 African states, 19 from Asia Pacific, 20 from Eastern Europe, 28 from Latin America and Caribbean, and 25 from Western Europe and other, meaning Australia, New Zealand. Significant major states are not parties. Obviously, the United States, China, India, Israel, and Russia. They are not parties to the treaty. And there were two states that actually were parties that withdrew, Burundi and the Philippines. And there is a provision that states can pull out of the International Criminal Court, but they have to give a year's advance notice, and any ongoing case that has been started is allowed to continue, but no new cases can be brought. So let me say a little bit about the structure and what is covered under the International Criminal Court. So war crimes, violations of the laws of armed conflict, which I've mentioned, crimes against humanity, the definition as I've put up there that I mentioned before, genocide, and then aggression, right, which was called crimes against peace at Nuremberg and Tokyo, which was not included within the Yugoslav or Rwanda tribunals. And so aggression was also added. There's a special jurisdictional regime for aggression, which I'll mention in a minute. So those are the crimes, right? Anything that doesn't reach to that level, so torture, for example, in and of itself is not something that can be prosecuted by the International Criminal Court. A mass shooting, unless it rises to the level or it takes place in an armed conflict or crime against humanity or genocide, right, cannot be heard by the International Criminal Court. And then the question is, well, who do they have jurisdiction over? So there's two, because of the crime of aggression, there are two different jurisdictional regimes in terms of the types of people over whom the International Criminal Court can assert jurisdiction, that is, assert the right to prosecute and, if successful, convict somebody of one of these international crimes. So the most general, and except for the crime of aggression that applies to all of the other crimes, an act, one of these international crimes, that is committed on the territory of a state party, they have jurisdiction. Doesn't matter who's committed the crime, as long as it's on the territory of a state that has agreed to the jurisdiction of the International Criminal Court. And, this isn't really that surprising. If you think about a US citizen who goes to France, for example, and commits murder, right? Well, France has a right to prosecute that individual for the murder in France. Now, the US may also have the right, but usually, unless France doesn't want to, right, it'll be France that prosecutes that individual for that murder. So the ICC, it's the same idea, right? If somebody is in a state that has agreed to this legal regime and they commit one of these crimes on that state, right, it is though it's part of their legal system. It just happens to be an international legal system in The Hague. So on the territory of a state party, or any crime committed by a national or state party anywhere in the world, right? So if you think about a UK national, the United Kingdom is a party to the Rome Statute, let's say commits a war crime in the United States, for example. The United States is not a party to the International Criminal Court, but because the person who's committed the crime is the national of a state that has agreed to the jurisdiction of the International Criminal Court, that individual can be prosecuted for that crime, even though it happened in the territory of a state that's not party to the statute. Aggression has a special definition, and this was something that the United States pushed for, even though we weren't members of the court. And I was actually present during the negotiations for this. This was in Kampala, Uganda. The United States had by far the largest delegation there, which people were a little annoyed at because we weren't a state party. And one of the things that and it wasn't just the United States, there were some of the other European states were on board with this, with respect to this issue, wanted a very specific jurisdictional regime with respect to the crime of aggression. And this becomes really relevant when we talk about Russia and Ukraine. So under the crime of aggression, you can only prosecute somebody if they are both the person who's committing the crime of aggression, if they're a national of a state party, and they've committed the crime of aggression on the territory of a state party. So it's not the or, it's the and. So with Russia, well actually we'll go on to the next slide. So with Russia, Ukraine, there's no jurisdiction over Russia for the crime of aggression against Ukraine, because Russia is not a party to the Rome Statute. So Putin, Russian generals, since they're not nationals of a state party, they don't have jurisdiction over them, even though Ukraine is a party to the Rome Statute, so the crime is occurring on the territory of a state party. So the crime of aggression cannot be prosecuted by the International Criminal Court in the case of Russia and Ukraine. But they can, because Russian forces are engaging in activity on the territory of Ukraine. The International Criminal Court does have jurisdiction over whoever those people are, right, including Russians, that are committing those crimes on the territory of Ukraine. So war crimes, crimes against humanity, or genocide. So the International Criminal Court has indicted 4 individuals: Vladimir Putin, the president of Russia; Maria Lvova-Belova, who's I think her title is Ombudsman for Children's Rights or something like that. And what they are both being charged with is a war crime of unlawful deportation of population, primarily, although not exclusively, children, and unlawful transfer of those children from Ukraine into Russia. There's also 2 Russian nationals, 2 generals, or I guess a general and an admiral. Somebody from the armed forces, Sergei Koblash and Viktor Sokolov. And they are being charged with the war crime of directing attacks against civilian populations, as well as crimes against humanity against civilian populations. None of these 4 individuals are within the jurisdiction of the court, right? So these are just outstanding arrest warrants. And during the question and answer, we can maybe go into this more. What's the how useful is this? What might happen, right? So the second situation, Israel-Gaza. The International Criminal Court has jurisdiction over any of those international crimes, war crimes, crimes against humanity, or genocide, committed on the territory of a state party, and Palestine is a state party to the International Criminal Court. So Israeli officials, Israeli citizens, if they engage in international crimes in Palestine, there's jurisdiction over them. If they engage in international crimes, including, within the territory of Israel, they're not within the jurisdiction of the International Criminal Court because Israel is not a party. Hamas, when they crossed over into Israel on October 7th, right, committing atrocities. So they're committing atrocities on the territory of Israel, which is not a party to the Rome Statute. But because they are nationals of Palestine, the ICC has jurisdiction over them for that crime committed in the state of Israel. Actually, this is out of date. There are actually arrest warrants that have been issued. I guess at the time I originally wrote this, it was still just a request. So when the prosecutor wants to issue an arrest warrant, charge somebody for an international crime, he or she, now it's a he, has to go before a 3-judge panel. So there are some checks and balances within the International Criminal Court itself in terms of the exercise of these sorts of powers. And arrest warrants were issued against 5 individuals, so 3 leaders of Hamas, all 3 of whom now, I think is confirmed, are dead. So those cases, although I think Yahya Sinwar technically is still up on the ICC website, but Deif and Hani, those cases have been dropped, and I assume Sinwar will be dropped soon as well. They were being charged for war crimes and crimes against humanity, committed both on October 7th and afterwards. And then 2 leaders of Israel, Benjamin Netanyahu, the prime minister, and Yoav Gallant, who was the defense minister, now former defense minister. And they're being charged with war crimes and crimes against humanity, including starvation and persecution related to the conflict in Gaza, in Palestine. Just as a side note, there's another proceeding with respect to Israel's activities in Palestine happening before something called the International Court of Justice, which is not the International Criminal Court. That's the case that South Africa and now many other states have joined on, have brought against Israel for violations of the Genocide Convention. And the reason that they're or one of the reasons they're bringing this under the Genocide Convention is that that gives the International Court of Justice jurisdiction over the dispute. They couldn't go before the International Court of Justice with a claim of war crimes or crimes against humanity. They can only go there with respect to a claim under the Genocide Convention. And I'm happy to talk more about that case and how it relates maybe to the International Criminal Court also during questions if people want. Most recently, in January, and I think this is probably, there's probably legitimate reasons for this, but also probably a smart political reason on the part of the ICC prosecutor, who's gotten, and I'll talk about in a minute, blowback a little bit with the Russia indictments, but very much so with the Israeli indictments in particular. Just this January, requested arrest warrants against 2 Taliban leaders in Afghanistan for the crime against humanity of persecution on gender grounds, which some people talk about as gender apartheid, even though that's not a crime under the International Criminal Court, so that's not what the charge is for. So those are the most recent indictments, arrest warrants that have been, actually that's a request for those indictments by the prosecutor to a pretrial chamber. Just to give you a sense of where the ICC is involved, these are the active investigations. There are another 5 that have been closed, and there's a lot of other areas of the world where the International Criminal Court is looking. And in fact, this map shows you the red colors, to the extent that you can see those. Yeah, I guess you can see that a bit. Are the closed situations. So Colombia is one, Venezuela is another. But a lot of the situations, actually all of the initial situations were in Africa, and that we'll get to one of the critiques I'm going to talk about in a minute. So you have the Democratic Republic of the Congo, where there's renewed fighting now, just starting about a month ago in eastern Congo. Darfur, Sudan, and Sudan is in the midst of a major internal armed conflict, civil war. Libya, Cote d'Ivoire, Mali, Burundi, and Burundi pulled out, but that case continues. Palestine, which I referred to, Bangladesh, Myanmar, Afghanistan, Philippines, Venezuela, and Ukraine. So let me then talk about sort of some of the critiques or concerns about the International Criminal Court, sort of the focus, I guess, of this talk. The first is money, and there's certainly people, friends of mine in the human rights world, who make very, not always so publicly, but very strong arguments about the sort of distortion of resources at the international level in terms of human rights and protection of individuals towards this sort of retributive justice model, which I'll refer to again in a minute. So the budget is roughly $202 million. It's been, I think it was as low as $100 million when it got started. You know, on the one hand, maybe not that much money when you look at, you know, government budgets, but still a fair amount of money. $200 million is an awful lot of money for most of us, I assume all of us here. That money is funded by state parties, so it comes from all of the states that have agreed to be parties to the International Criminal Court. And I list here the largest contributors: Japan, Germany, France, and the United Kingdom are the largest funders of the ICC. The United States doesn't provide any money to the International Criminal Court. We have in the past provided some assistance from time to time, investigative assistance, some other in-kind assistance, and that's varied depending on who's been in office. So under the Obama administration, there was more engagement. Biden, there was some engagement. Trump, not only no engagement, but actually active hostility. George W. Bush, sort of hostility, although under George W. Bush, the United States agreed to cooperate particularly in his second administration, with some of the activities of the International Criminal Court. There have been 11 individuals that have been convicted, right? So the International Criminal Court's been around now for about 20 years. It started in 2002, I think, is when they started their operations, a little over 20 years. 11 individuals, not that many, and actually only 6 of them have been convicted of what we would call international crimes, so war crimes and crimes against humanity. 5 of the others were for witness tampering, which is important, but it's not, right, one of the atrocity crimes that the ICC was set up to deal with. 4 individuals have been acquitted. That's sort of, I view that as sort of a good sign. That is, not everybody is being convicted. And in fact, Nuremberg, there were a few German nationals that were acquitted. Not everybody was convicted at Nuremberg. Japan, on the other hand, there were no acquittals. Every Japanese defendant was convicted, and there's some question about whether some of them perhaps should have been. There were some that were actually trying to stop the war while they were in government, but because they were in government, they were held responsible for the conduct of the war. There have been over 50 individuals that have been indicted. 21 of them are in custody. There's 31 of them at large, which would include all of the people I just mentioned to you in the previous slides. Oops, sorry, I keep hitting the wrong. So let me briefly mention some of the critiques. So one critique that was became very vocal in the first 10 or so years of the International Criminal Court was this accusation that the International Criminal Court was, quote, targeting Africa or targeting the global south. And it is true that in the beginning, all of the situations the International Criminal Court was investigating were in Africa. The reason for that is that in those early days, all of those situations were actually referred to the court by those African states themselves. That is, they said, we would like you to come in and deal with this conflict that we have within our territory. So the targeting Africa critique, at least at that stage, seemed a little weak or disingenuous. There have been a couple of situations. So the UN Security Council under the International Criminal Court has the power to impose jurisdiction on a state that is not a party. So, and the Security Council has done this twice. Sudan, which is not a state party to the Rome Statute, and Libya. In theory, right, the Security Council could do that with Israel, could do that with the United States, could do that with Russia. Obviously, that's not going to happen because you have the United States or Russia on the Security Council with veto power, so it would never, none of those state situations would get through. And so once you had the Libya and Sudanese situations, it seems to me there's a little more of an argument that there's this, at least perhaps disproportionate focus on Africa as opposed to other parts of the world where there are atrocities happening, whether it's Iraq, Iran, Afghanistan, Myanmar, other parts of the world. Georgia, which later came within the court's jurisdiction. And I sort of view this critique really as, I think, somewhat legitimately aimed at the International Criminal Court, but really more aimed at our global power structures, where global power is actually in the global north, big powers, the United States, China, Russia, Europe, vis-a-vis the global south. And you see that in the structure of the United Nations, you see that in our economic structures, right? So this is just another manifestation of that same maldistribution of global power. The second critique, which I sort of made a reference to, the good friend of mine has articulated quite compellingly to me, is that retributive justice, this idea of prosecuting people, doesn't do much to help people on the ground. It's very expensive. And to the extent that it is the focus where energy is being shifted, both in terms of people resources and monetary resources, it's taking money away from things that might actually be doing more to help human rights of a broader range of people. Now, having said that, I do think there's still some value in retributive justice or some type of criminal justice. And Susan made reference to the work I do with the Law and Peace Practice Group based in Barcelona, and that's sort of at the heart of a lot of the work we do, trying to think creatively about not really retributive justice, but other forms of accountability as a way to try and help negotiate ends to atrocities, ends to authoritarianism, ends to civil conflict. Yeah.
What's the meaning of retributive?
Retributive meaning that the idea is to punish. So it's like you did something wrong, and we're going to, hit you. Although we don't hit you now, we incarcerate you. We put you in jail. So it's a form of punishment, as opposed to alternative is restorative justice, which can include some punishment, but retributive justice looks at the individual perpetrator, says this person did something wrong. We want to focus on whether we have enough evidence to say that what they did was wrong. If we find that they did, then we're going to punish them. We're going to put them into jail. And part of the idea there is when they're in jail, they'll be rehabilitated, which in practice tends not to happen so much, at least in the United States. Some countries do it somewhat well. Restorative justice is really looking at, well, what we want to do is figure out who, whether this individual is responsible for this violent act, but think about what's the best thing in terms of bringing society, healing all of society, victims and the perpetrator and society at large. So it's some people sort of posit them as very different. I don't think they are that different. I think because restorative justice can include punishment, but I think the difference is really the sort of, I guess, the frame in which one looks at the criminal activity and how to address it. The last critique, also a friend of mine wrote a whole book on this called Distant Justice, is that this is justice that's happening in The Hague, it's happening in Europe, right? That's where the International Criminal Court is housed, and it's very far removed. I mean, it's a little similar or overlaps with some of the critiques of the second one. It's very removed from the areas where these crimes were committed. So people, you sort of hear maybe, you've heard the phrase, justice needs to be seen to be done. Well, the problem is if justice is happening so far away, and it's hard to see it, and so there's not a sense that, in fact, justice is being done, even though technically, maybe, in fact, it is. Let me talk a little bit about political pushback. And these were the only things I could find. This one I sort of like a little better than the one I'm about to show you with respect to Israel and Gaza. But this is a map that sort of sets out what the political reaction is to the arrest warrants against Vladimir Putin. And you can sort of see, it's a little complicated, and actually I guess I don't have a pointer. But if you look, the purple line, right, those are ICC members, so all of the states within that are members of the ICC. Then that blue box that's a little bit off to the left, those are countries that have said favorable things or have done favorable things with respect to the arrest warrant that's been issued against Vladimir Putin. So there you have NATO, the United States, European Union, many European states, other states. Interestingly, critical over on the right, the red, and then BRICS, which is Brazil, Russia, India, China, and actually now includes more states than that, have been critical of the arrest warrant against Vladimir Putin. So we, sitting in the United States, we tend to think, oh, the arrest warrant against Vladimir Putin makes sense. Most people would support it. Clearly what he's doing in Ukraine is a crime and a lot of crimes being committed. But that's not completely true. There are some states that have been critical of the arrest warrant. South Africa being in some ways the most surprising given its history of human rights, although maybe not so surprising given some of the politics in South Africa. For Israel and Gaza, so I apologize, I couldn't find anything better than this. Those little flags indicate different things in terms of the states. So let me just tell you roughly. The green ones and the yellow ones are states that are supportive of the issuance of the arrest warrants against the Israeli and Hamas officials. The blue ones are states that are sort of non-committal. They haven't sort of said either way. The purple and maroon ones are states that are members of the International Criminal Court but have refused or say they have refused to cooperate with the International Criminal Court on those arrest warrants. And red is also negative. And so the United States is red. The United States is not a member of the International Criminal Court, but the United States has been very critical of particularly the indictments against Netanyahu and Gallant. Okay, lastly, yeah, okay with time. The U.S. sanctions. So this is a new development. President Trump, in one of his, it's like 100 executive orders so far, one of his executive orders imposed sanctions against the International Criminal Court. He had done this, or something like this, during his first administration. So the order authorizes asset freezes and travel bans against any ICC official, any employee, and any family member of such an official or an employee. So that's one basket of people that are subject, right? This is just opening up the possibility. This order, with one exception, which I'll say in a minute, didn't impose sanctions on anyone yet. It also authorizes similar sanctions against foreign nationals who are deemed to have helped the court with its investigation. So not U.S. citizens that are helping, right? Although U.S. citizens could fall under, there's some other parts of the order about if you're aiding people in that first category or in the second category to avoid these sanctions, and it's not really clear how broad that would be interpreted, perhaps a U.S. citizen might come under something here. But generally, I think the idea is not to focus this, at least at the moment, on U.S. citizens. And so at the moment, there's only one person. So this executive order says, here's this authority to do these things, and then we're going to list, over time, who we're going to impose these against. And at the moment, as far as we know, it's only one person, Karim Khan, who's the prosecutor, a UK national, who's been prosecutor for about 3 or 4 years, is the prosecutor that did bring the claims against Russia, also brought the request for arrest warrants against Netanyahu and Gallant, as well as the 3 Hamas officials. So let me maybe stop there. We got, another 15 or 20 minutes, and ask if there are any questions or anything you want me to elaborate on that I've spoken about. And maybe I won't keep that man's face on the... Maybe I'll just go back to the beginning.
Yes, here's a question. I think it's on. Seems to be on.
Yeah. I'm not clear about the 5 countries, Russia, China, the United States, Great Britain, and France, that are prevented from any kind, that can use their status as founding, whatever it's called, of the founders of the UN, they can use it even if the charge against them is not relevant to that distinction, right? They can stop the United States can stop any charge against it for any reason at all.
At the Security Council, yes.
At the Security Council,
yeah,
right?
That's right.
So doesn't that need correction?
Yes.
No, not because it's the United States.
Yeah.
It's so bad.
No. Yeah. So let me maybe explain, not defend, explain why it is the way that it is, and then maybe in that also sort of part of that's answering your question about shouldn't it be changed, and if so, why is it not being changed? So when the United Nations was created, so there was the League of Nations at the end of World War I. Part of the problem was the United States didn't join, United States growing global power, and the League of Nations, falls apart, and you have World War II. So it's like the League of Nations is viewed as a failure. And part of the analysis was that you really needed the powerful states to be part of such a global security system in order for it to work. Because if you had powerful states that weren't going to be a part of it, then you weren't going to be able to stop or at least minimize the negative activity of those powerful states. So the carrot to get powerful states into the United Nations system was the creation of the Security Council, which is really the most powerful body at the United Nations. It is the one body that can issue resolutions that are binding on all states in the world as a matter of international law. No other part of the United Nations can do that. And the 5 permanent members, the United States, Russia, China, the UK, and France, all have veto power. And you're right, there is no, now academics, talk about, well, let's say, these are all hypotheticals, let's say that, genocide's being committed in the United States. Does that really mean that the United States could veto a Security Council resolution, sort of calling on states to stop the genocide? And one can come up with some arguments using natural law, maybe customary international law, to try and argue that maybe the Security Council, if it did that, is acting illegally, or the U.S. is acting illegally. The problem is there's no higher body to go to say what you're doing is, quote, wrong. So yeah, you're right. What it really means is that those 5 can pretty much, they can turn on or turn off the spigot in terms of Security Council resolution.
If Trump was not president of the United States, could the United States go forward with accusations against him and anybody?
Well, sorry, yeah.
If Trump were not the president of the United States, would it be possible for the United States, as a member of the Security Council, to go to allow a United States citizen to be, even if he was the ex-president or former president, to be indicted for things that, as a member of the Security Council in the present format, that can't happen?
Yes. Although the Security Council right is different than the International Criminal Court, the Security Council could, although I can't believe that any U.S. administration, Democrat or Republican, would agree to this, could impose jurisdiction on the United States through a UN Security Council resolution, as they did with Sudan and Libya. So even if Trump, whatever he does, I don't see the U.S. saying, okay, we want the ICC to come in and deal with this. But you're right, though. A former president under U.S. law has a lot of immunities from prosecution, and actually more so now, given the recent Supreme Court opinion. But the United States can waive, well, actually, can they waive? Yeah, I guess they can waive those immunities as a matter of international law. So they could do that if Trump somehow was being prosecuted by the International Criminal Court. And the way that could happen is if Trump engages in some activity that rises to the level of one of these international crimes on the territory of a state party, so Palestine, given what he's talking about with Gaza maybe, Ukraine, depending on what's going to happen with Ukraine, maybe, right, you can make an argument that there's jurisdiction over him for that. And then, you got a big political issue. I mean, whether the United States, whether, post-Trump, even Democratic administration would agree to hand over a former president seems to me pretty unlikely, although I don't know, who knows, No, I mean, I do think there's this institutional, like if we hand Trump over, then, who else is going to be handed over? So
I want to thank you very much for a very illuminating discussion. I would like you to dig a little bit deeper into what is the unique, if there is one, crossroad at the moment.
Well, I think, so by crossroad, what I mean, I think there are some serious challenges that are facing the International Criminal Court. Some of them have been around for a while, so that sort of targeting the South, if you will, sort of not looking much at global North atrocities or activities, the distant justice, et cetera. I do think going after Putin, and then particularly going after Israel, right, has created a very large political backlash, and that has consequences, right, in terms of political support, maybe even financial support. And, there are, I just read an interview with actually the guy who heads the organization I work with in Barcelona, the conversation was about, is the International Criminal Court about to die, is about to, disappear, which I don't think is going to happen, but I think there's, I think there's some serious questions being raised about how effective this institution is. And they're coming from many different places, right? I mean, they're coming from, people that don't want any inquiry with respect to what Israel is doing, right? But they're also coming from people who are like, even if I support, looking at what Israel is doing, there's still some problems with this institution. It's not very efficient. It's, if you go back to many of the countries where it has prosecuted people, how much of a difference has it made, right? Maybe there's a need to sort of rethink what role this court should be playing. So I think, the Trump, Israel, and to some extent Russia provides a political sort of weight to this criticism, which, none of which I would agree with, but it opens up a space for rethinking perhaps what this institution is doing, given some of the other criticisms that I would be much more sympathetic to.
This has been a very helpful discussion. Could you review for us, the United States has refused to join this enterprise through many administrations. Can you review the reasons that we used to not join?
Yes. So the United States, so Bill Clinton was under the Clinton administration. Bill Clinton decided to sign, this is sort of legal technicalities, but agreed to sign the Rome Statute, creating the ICC, but said that he was not going to send it to the Senate for ratification because, and I think he's right, it would never be ratified by the Senate. So he sort of, had his cake and ate it too. Like, he's supporting it, but, we're not going to join. And there's some legal significance to that, which I won't go into. The U.S. arguments, there were a couple. One was that the International Criminal Court, and particularly the prosecutor, would bring politically motivated prosecutions, through some anti-American lens, whatever that would be. And so there would be this unfair targeting of the United States, and maybe not just the United States. Second, there were arguments about due process, that is, that if a U.S. citizen was, prosecuted in the United States, you have a right to a jury trial. There is no jury trial in the International Criminal Court, so there's at least they made the argument, of violation of individual constitutional rights through this system. There's no jury trials in France, right? So we don't say that somebody who's being prosecuted in France has their constitutional rights being violated. So that I think is sort of weak. Third, and this is maybe a little bit related to the first, the United States has the largest footprint globally militarily. We have military forces in many parts of the world, and then the argument, which is, there's some truth to this, but this maybe oversimplifies it. A lot of times they're out doing good things. They're engaged in peacekeeping, they're engaged in other sorts of positive activities, and that this would provide sort of a vehicle for people, again, to illegitimately, for political reasons, to really try and prosecute U.S. military forces who are doing good things, who aren't in fact engaged in these sorts of crimes. So those are sort of the arguments. The counter arguments are, I think the constitutional ones are sort of silly. The sort of targeting, America or American military personnel, there's a fair amount of checks and balances that are within the court. You've got a lot of powerful European states, United Kingdom, France, Germany, that are parties. They don't seem to have this concern, and they're somewhat active in different parts of the world as well. And then frankly, the United States still is, I think it is still the only superpower. We're sort of losing that over time. But so if that were to happen, it seems to me there's a lot of remedies that would be available and options that would be available to the United States. So I sort of tend to not take too many of those arguments seriously. I would say the other, which isn't articulated, I think the other is, historically, we don't like outsiders judging us. Like, we don't like outsiders coming in and telling us what to do. And I think that's sort of at the heart of this. It was actually the reason we didn't, for a very long time, ratify the Genocide Convention until Ronald Reagan, actually, in 1988, is when we finally joined the Genocide Convention.
Yeah. Does diplomatic immunity supersede a warrant by the ICC?
No. Sorry, I couldn't see who asked the question. Oh, okay. No. Under the ICC statute, sorry, you can, there are no immunities don't apply, so head of state immunity does not apply. There's some arguments about that, and I think it's pretty clear that it doesn't provide a defense to a sitting head of state, someone like Putin or Netanyahu, in being prosecuted by the ICC. There are other issues that come up if Putin or Netanyahu travels to a state. Those states, if they're members of the ICC, at least under their treaty obligations, they are supposed to arrest them and hand them over to the ICC. There's some arguments that I don't necessarily agree with, but they're not frivolous arguments, that there may be immunity issues there, that even though the immunity doesn't protect them from the ICC itself, the sort of state to state, where you have a head of state traveling into another state, right, that other state, at least they make this argument, have some legal obligation to recognize this immunity. And there's a logic to that. I mean, part of the reason of having diplomatic and head of state immunity is that we want people to travel around to negotiate, to talk. And if we say, if you go to this other place to engage in peace talks, you might be arrested, then people aren't going to go engage in that activity. So I think there's some arguments that support some of the arguments that are being made to say that perhaps that immunity still has some force. I tend to argue the other side of that, but I don't think the side I disagree with doesn't have some merit.
This court was obviously very difficult to set up. It's very complicated. It has certain powers, but it's not perfect. If you were able to suggest one major change that could be made to make the court more effective, what would that be?
Anna, did you hear what I said? I answered that. Can we go on to the next question now? Wow, that's a great question. That's the sort of question I ask my students sometimes. So now I feel maybe I won't ask that. I guess it wouldn't be a structural change. I think what I would recommend, and I think this Karim Khan, the prosecutor, has made some moves in this. I would sort of recommend that the prosecutor in particular, but the institution as a whole, start to rethink what their purpose is. So one purpose, right, is that they are this court of last resort for these limited international crimes. And I wouldn't say necessarily to get rid of that, but really to think a little more creatively and proactively about what the court can do in terms of providing assistance, technical assistance, other sort of assistance to states that are trying to deal with and prosecute people within their own territories. And the International Criminal Court has done some of that over the years, not a lot, but I think seeing themselves as themselves not as an either or, either it's going to be, in, Ukraine or Kenya or, Israel or Palestine, or at the International Criminal Court, but see it as more of a partnership. And I think there's been this sense of sort of being very absent and distant from what's really happening on the ground. And I was working in Kenya when the International Criminal Court was active in Kenya. And so I saw a lot of that firsthand, how they International Criminal Court investigators came into the country, and number one, the government restricted what they could do, which that was not the ICC's fault. But they just really had no idea what they were looking into, and they didn't really have the support, and they didn't have the local sort of contacts that would give them the legitimacy to start to get that trust and information on the ground.
if if any of these characters were to be convicted, what would be the possible punishment?
So they can be incarcerated, and there's some that are in jail. It's interesting, and I asked a friend of mine who was in the State Department, is not there now, obviously, doing this sort of work, and she didn't know what the reason for this was. But for some reason, the International Criminal Court, under sentencing, they can give a sentence up to 30 years, so nothing more than 30 years, or life. Yeah. Which is sort of weird. And I'm like, well, why that gap, right? I mean, if somebody's 80, then yeah, that's your life is not going to be more than 30 years. But I don't know what the rationale for that is. I will say, you know, U.S., my law students, when I talk about, you know, we look at some of the sentences, and it's like 25 years, 15 years, which from a U.S. point of view looks really small, given the level of the atrocity. But if you look in other parts of the world, including Europe, those are pretty long sentences. The U.S. is a bit of an outlier in terms of the harshness of our sentences. But why there's this weird gap between 30, like you can't do 30, like if you're at 30 and you think 35 is justified, you either got to go to life or go back to 30. I don't know why that is. So.
When Milosevic was convicted caught, convicted, did that make a difference psychologically or otherwise to the other former Yugoslavian countries, seeing that, yes, one of their horrors is no longer there, therefore the other countries better behave, so to speak, including Albania?
Yeah, I mean, that's the hope, right? The hope is that if you prosecute these people, hold them to account, it creates some deterrence and some caution. And I think undoubtedly there's some of that, but I think it's been weak. And in the former Yugoslavia case, which you may know more than I, it was quite the International Criminal Tribunal for the former Yugoslavia was very controversial within the country, particularly with the Serb population, although not exclusively with the Serb population. And their perception, and they propagated this through their media, was that this was really an anti-Serb court. So the idea that what this was going to do would be to try and, part of the idea of Nuremberg was, let's not punish the state of Germany, right? It's not the state, it's not everybody in the state that was supporting this, although there were a lot that were, or at least not opposing it. But let's go after the individuals. And the idea of you go after the individuals, then, right, that lets the state say, okay, yeah, these people were criminals, they're now being punished, and we can now move forward. And that's the theory, and I think that can work. My view on that is that we're in this sort of early stage where the deterrent factor of being indicted by the International Criminal Court is still pretty low, because people look and they say, oh, well, you know, Putin's indicted, but look, he's still running Russia. You know, Netanyahu is coming to the U.S. and whatever, right? That, you know, these things don't really do much. I mean, they do some, but they don't do that much. I think if it gets more robust, so that you do have prosecutions and people are actually thrown into jail, then people will maybe start to, sort of rethink their calculation in terms of the types of activities they're engaged in. But yeah, Milosevic, I mean, Yugoslavia, there's a lot of interesting studies about how the tribunal, didn't, maybe exacerbated ethnic tensions at times. Not necessarily because of what the court was doing, although the court was, I think, rightly criticized for not doing, later they did, but not doing much outreach. Like, they sort of saw themselves, we're a court, we're prosecuting, let's do that. And the idea of, like, trying to go and explain what they're doing and to engage with people was not something that they did. And I think that's a little bit of a problem with the ICC. I mean, the ICC does more of that, but I think a lot more of that is needed. I think, justice is a collective enterprise, and you really need political support. Forget the legal structures. And if people don't believe that this is a good thing or that it's justice, then it doesn't matter how good the institution is. I mean, you see that with the reaction to the Israel indictments, right? I mean, there's just, the institution is illegitimate without people who don't really understand the institution, which doesn't mean that maybe the Netanyahu indictments was a good thing or a bad thing. It might not have been a smart thing. Certainly, maybe not smart politically. So, yeah, go ahead.
How many people actually have been sentenced and imprisoned, and what happens to them apart from being isolated from their presumed world? How are they treated? What do we learn from it?
So there are 11 that have been convicted at the ICC. I think they are all, no, actually, I think some may have been released, but most of them are still in prison. So they go to, well, I think for the ICC, it's mostly European states, usually some of the Scandinavian states. They've agreed to take some of the prisoners. There's the Rwanda Tribunal and the Yugoslav Tribunal. They had states agree to take prisoners. So Rwanda, for example, there are people convicted by the Rwanda Tribunal who are in different African states. I mean, there was a weird, and this is getting maybe a little bit back to some of the incentive, there was a weird issue in Rwanda where, so Rwanda, after the genocide, you had the International Criminal Tribunal, but you also had jails in Rwanda and prosecutions in Rwanda, and there were 100,000 people in jails in Rwanda, and they were overflowing. They were horrible. It was horrible conditions. The people that were most responsible for the genocide, they weren't in those jails. They were sitting in Arusha in a UN facility in a pretty, I actually walked through the prison, and met some of the defendants. They have TV. There wasn't, I mean, it was, yeah, we didn't have to go through a locked door even. I guess there was a locked door. Well, it actually was, I think it was there was a nice model there, but the disparity in terms of, so there was this sense that, if you're one of these people, you want to be indicted by the ICC because you want to spend time in jail in Sweden and not in, whatever your country is that you came from. So, there's sort of weird, in fact, Saif Gaddafi tried to argue that the ICC should prosecute him and not the Libyans, because he was afraid that he wasn't going to have a fair trial, they were going to maybe summarily execute him. He wanted to go to the ICC. So yeah, you have these weird sort of dynamics that are created because of that.
So where do you tell your idealistic law students in the field of human rights that they should work in order to make a difference in the world order?
Wherever they can, including in what they're doing day to day. I mean, I tell students, so it's unusual to come right out of law school and go directly into what we would call an international human rights organization. Sometimes it happens. So what I start to talk to them about is, what are your interests? Your interest in, women's rights, indigenous people's rights, environment, what's your passion? And then let's figure out, right, when you're doing that sort of work, domestically, whether it's in Washington State or the United States or whatever it happens to be, that is sort of human rights work, right? That is, you're sort of pushing for and trying to protect and enforce individuals' rights with respect to whatever the particular issue is. When you do it initially, you may not be using international law as much, but you can sort of look to that and you can keep your eyes open, and there may be ways to bring it in at times. And then as you do that and opportunities arise at some of these international organizations, you're in a better position to be able to take them. But there's a lot of really good organizations out there, both here in the United States and overseas, that are doing lots of good work in human rights and other areas.
Are we?
Okay.
I think we've just about covered it. Thank you. It's been a good discussion. We really appreciate you being here.
And thank you. It's really
Thank you all.
educational.